All right, it's 3:30. We'll go ahead and call the Warren County Building Code Appeal Board meeting. At this time, I need to have a motion to adopt the agenda.
I make the motion.
Second. We have a second. All in favor, say aye.
Aye.
Any opposed? At this time, I would like to have a motion to proceed to old business.
I motion.
I second.
Motion is made and second. All in favor, say aye.
Aye.
All opposed? Motion passes. Okay, we're opening up old business on a continuance of Appeal 1-2018. Christy Atwood, appeal a matter concerning enforcement of the 2009 Virginia Uniform Statewide Building Code. At this time, I would like to offer both sides about 10-15 minutes if you have anything that you would like for us to say to us before we close the meeting to actually vote on the appeal. So, Mr. Beam, and there will not be a rebuttal, okay? So, Mr. Beam, I will let you go first. Yes, we will have, and we will also have time for the board to ask questions to both parties.
Okay.
Mike is not.
I don't think it works.
We can hear it.
Okay. During the work session, the information that was coming up was, I believe, I'm almost sure that these are code violations. Code violations are code violations. They come along with a code section, specifically, not I think, I believe. Anytime that a code violation is present, we have to provide the code section specifically. If you, and I don't think that you have the USBC in front of you, but if you look at the inspection section, which is 113 of 2009, when you perform one of the inspections that's required to be inspected, 116.6, approval or notice of defective work. The building official shall either approve the work in writing or give written notice of a defective work to the permit holder. The second part of that is, upon request of the permit holder, the notice shall reference the USBC section that serves as the basis for the defects, and such defects shall be corrected and re-inspected before any work proceeds and would conceal such defects. Now, we were talking about a two-year time frame as well during the last time frame, as far as the information that you have in front of you. 2 years is what the code allows the building official to go back against work that may have not been found, may have been a problem. So there is a 2-year time frame. So where I'm going with this is that for the inspections that are done on site, the only requirement is to say approved. That's it. No further documentation, no anything. To go back and start questioning, okay, well, did he look at this? Did he look at that? Did she look at this? Did she look at that? You can't do that because it's approved or it's not approved. And then you have to go forward to get it approved before it's taken care of. Obviously, there are items that are sent out with a notice of violation to be re-inspected once they've been corrected. Once those are corrected, those violations will be removed. The code also allows that if the code violations are not removed and they're refused to be removed, after a 2-year time frame, after that 2-year window, what you're required to do by code is to note that on the as a modification on the permit, on the certificate of occupancy. And that's the stopping basis for that. If you can't get them approved, you place them on there saying you cannot get the violations corrected, and you go forward. So that on the certificate of occupancy, it states these are the violations that are present. That's pretty much all I have to say at this point. Questions?
Any questions, Mr. Hatcher? Mr. Webb? Mr. Hotek? Okay, Mr. Hotek has one. Mr. Beam?
I have a question. Mr. Beam's reference was to USBC when he was reading that. Weren't you guys talking about a Virginia code for most of our discussion up there?
The USBC is the Virginia Uniform State Liability Code, USBC. I apologize, it's the acronym that's complex.
Mr. O'Day.
If I could hit you with some specifics.
Mhm.
I realize you gave us a general. Item 19 on your list.
Interject, please. Did he give you another handout that we don't have?
No, this is
No.
the
That's that, okay.
response.
His response?
Yes,
Do you not have that?
No, we do not have that.
that should have been provided to us through you.
Oh, I mean, have that, but is that the only paper?
No, that's the cover sheet.
Okay, and because there was hardly any on that one. Well, I have that.
That should have been supplied to us from you with your appeal.
I did have that. It's the notice of violation.
You have to notice the violation.
But is it only that, what Mr. Beam reported on?
Yeah, all this is the violations that you reported.
Oh, that we reported?
Yes, that you
Oh,
reported,
okay,
and
then
he
we
is
have
just giving us a rebuttal to those. Mr. O'Day, will proceed.
Point of order, if they don't have this, this is the document that we're reviewing.
Well, this
They
document
should
came
have-
with our original package.
They,
Is this what we,
Yeah, what's
This lists their charges from their third party.
I go in your direction. Should I?
We've never seen this.
What's this?
We've never seen this.
this was his responses?
Yes.
Yeah.
This was not provided.
No.
This should have been the
This-
basis of the.
You got it at
this
the last
vote.
meeting.
The notice of violation is what I provided to the secretary. The other document, I'm not sure where that came from. Is it done through FOIA?
Then this is not your document.
That is my document, yes.
Okay, this is what we're talking.
Okay. The notice of violation.
Yes.
And who's this? This
That was a document that was prepared for the board and submitted back to, I believe, Ms. Atwood for comments.
one?
No, it was not submitted back to
And I
us.
asked who the author of it was, against which building.
That was provided back to the clerk of the board
Wow.
and it's sent back. As far as I know, I believe I've got an email copy that confirms that it was sent back in
It's the same
responses.
document.
You want to give them a few minutes to,
Mr. Chairman, my point is, we have the first 3 pages. The rebuttal document with his comments following what we previously provided, this is the new section. It's somewhat disingenuous to suggest that all of this was part of this.
Yeah, I did, and I provided you.
That's false.
Not this.
The notice of violation we have, but all the attachments to it were not previously provided.
They were sent, I had attachments at the very beginning of this, where basically Mr. Beam went through and just put everything was cosmetic or civil matter, and then he was forced to drill down a little bit further, but that is not a document that I emailed to you guys for my appeal, and it was not handed out during the last meeting, so I'm not sure how you got it.
No, you passed this out, right?
No, I did not.
You didn't?
I did not provide the board,
Where'd this go?
this appeals board, the notice of violation. I did supply the notice of violation to the secretary.
So this came from-
Because the notice of violation is required to be submitted as part of the original submission.
Who made up this list?
Well,
Again, that list was provided at some point in time to the appellate.
yes, but I did not
This
provide that
is,
to
this
the
is your,
board.
this is your,
I didn't say that you did.
No.
this is your comment, is that correct?
yeah,
Those are my comments, yes.
Okay.
yeah, this was provided to us, right? This was, Christo? So all he is doing is just responding to your
Line item.
line item of 126 items.
All right, I'm just saying, I had not seen this before, today.
Well, sir, Mr. Sock, I'll be glad to give you some time to take a look.
I can read quickly. Thank you, Mr. Chairman.
Is there a question?
There is a question.
Yeah, I'd say we go ahead and proceed with the questions because you will be able to see this now because we're going to go over the line item, just like we did in the work session, okay? All right, Mr. McTack, proceed, please.
Sorry, lost my train of thought on that one. I'm sorry, I'll have to recollect. What I was trying to do was go into the issues, as you heard in the other room, and I think you were speaking to that, where you make specific statements that it's not addressed in the code. Like, for instance, we'll just use that as an example. Number 76.
76.
A temporary valve was not found for the master bathtub. This is a potential scald hazard. You were saying it met the 2009 code.
That is correct. The tubs do not require a scald valve. The shower head requires a scald valve.
Okay. So likewise, all these other items where they felt there was a code violation, you feel there's not for a similar tech reason?
Correct.
Thank you.
David, one quick question. In the 09 code, I wish I would look that up, but I know at some given time we switched from measuring the stair riser height from bottom of the door to the step versus top of the threshold to the step. Did that switch, was that in the 09 code?
No,
Did we
the
come from
measurement's supposed to be taken from the landing, the floor surface.
floor surface?
Yes.
Okay.
It's the thought by the code that you step over the
Over
threshold
the threshold.
and you're not stepping on it to give yourself a different elevation.
Okay, Mr. McFadden, do you have anything, Mr. B? Mr. Hatcher?
Can I go on build on George's? Number 99 then, because that goes back to that same issue. Could you address that? The stair riser heights differ by more than 3/8 from the house into the garage. The top riser height exceeds 8.5 measured at the top of the door threshold. So that is that very issue? Is that what you're...
That is the issue, yes. The steps themselves do not vary more than 3/8 of an inch, nor does the landing vary 3/8 of an inch or more from the steps. The threshold is outside of the picture.
So this measurement is from the bottom of the step to the top of the threshold, that's what you're saying?
That measurement that's provided, yes. And in the picture, it actually shows that.
Okay, anyone else? Okay, you're excused. Mr. B, thank you very much. You're excused. Okay, this time, Ms. Atwell and Mr. Silent, you have...
Your Honor, Mr. Chairman, we stand on prior argument as well as presentation. The issue isn't, well, let me put it this way. We already know the building inspector missed issues. He's acknowledged that with the notice of violations that he admitted on his second inspection. We contend there are more that things that he's previously approved, he ought not to have approved. But he did. And there's more. And those decisions, those prior approvals, are what we are appealing. So the ones that aren't cited, as we previously stated in his last notice of violation, all the other prior approvals in of the 60 set forth in the March 14 letter, those are the remaining ones that we contend ought not to have been approved and should be reversed and re-inspected again. Ideally, if the county were smart, and no one's suggesting that, if they were, they would hire someone to come in who's not tainted, who is an uninterested third party, to do a true independent inspection. Because that would be the right and the honorable thing to do. And to say, we screwed up. We shouldn't have done this. We shouldn't have approved this. And we know they did screw up. Because they did find more violations after the county administrator came to her and said, ask for another inspection. We contend there are more. And we would ask that the prior approval of the remaining items that weren't the subject of the notice of violation be found. Ask that be reversed. Thank you.
Thank you, Mr. Sonic. Ms. Atwood, do you have anything to add?
Thank you.
Okay. Thereby, I'll close the floor. If any member would like to ask any questions to Mr. Sonic or Ms. Atwood, you're free to do it this time. Ms. Hatcher, you will have any questions?
No, not this time.
Mr. Klein?
Come back to it.
Mr. Hotek, you have any questions?
Yeah, I do. So I'm going back to the document, the confusion over these documents.
Which document, Mr. Hurtak?
I'm about to tell you.
Okay.
It says review of possible code violations, construction deficiencies. More importantly, home build does not match county approved plans. Review, whatever that says, sent to the Forever Construction, see attached third-party inspection. So again, as we've said before, this board's the only thing that we can do is approve or disapprove the building officials' statements, whether something's a violation or not. So clarify with me once again, this is the documents that you provided with this document?
May I approach because I can't see what you're...
Sure.
Yeah, you come on up, Mr. Sonic.
So you're telling us that,
This is the notice of violation that we received.
okay.
This.
So with this document,
That is an appeal.
Right.
That's just a form.
right, you provided this.
We attached this as one of our documents, yes. This is the notice of violation.
Okay. Thank you.
Now, the supporting pages that you were questioning, we did not provide. We didn't have those.
Thank you for the clarification.
Mr. McMahon, do you have any questions, sir?
I don't.
Mr. Hatcher? Mr. Klein?
Yeah. I'm going to go back to I really think this has gotten to be way more confusing than it needed to be, in my opinion, because everybody's throwing all their opinions out there. I'm going to go back to the work session meeting. And again, I'm going to reiterate that the description of the appeal that you've done, I truly don't have in my possession of what you are exactly. To me, an appeal is if the inspector comes out and does a rejection, you have the right to repeal that rejection. And then we hear that rejection and we either go with it or go against it. I don't have that here. I don't have a rejection nowhere. We're all firm on that there are 5 code violations. You all have agreed, he's agreed, we agree, and they need to be fixed.
We're not appealing those, Mr.
I understand that, but what are you appealing?
The prior approval of the remaining 60. We, at the prior hearing, and offered into evidence before you all,
But who did the prior 60?
who approved them? Him, or his office. And they ought not to have been. And what The usual posture of people coming before this board is to appeal a violation, not an approval. That's the usual posture. But the opposite is what's occurred here. Okay, so we have 60 issues that my client contends should not have been approved. Not rejected. Typically, a builder comes in here and says, well, he violated this on this and says violation. We don't think it is. We want the board to approve it, to reverse the building inspector for the rejection. That's not what we're asking here. It's the exact opposite. And the statute allows that, to reverse his approval of these certain items. In this matter, an independent home inspector came in and said, these ought not to have been approved. Eventually, Mr. Beam agreed, in part, with that inspector, and then issued this, and reversed himself, because he had previously approved these things. Now, the inquiry from this board to Mr. Beam should have been, why did you previously approve these and then find that they're rejected? But y'all haven't asked him that. I don't know why, but that should have been the first question. Why did you previously approve these things that you later found to be a violation? That should have been, that is the basis for further inquiry. But no one's asked him that. Why? Someone in that office, whoever it was, committed error. Error to her detriment. And the building code is designed, and the law is designed to protect her. And it's utterly failed. It almost already sounds like, or seems like there's, well, we'll just brush this over. Let's forget about it. Screw her. That's how she feels already. When she was in here last time and Mr. Burracker was allowed to sit up there after he recused himself and look at her as she's trying to present her case, shouldn't have happened, but that's what happened. And she felt intimidated because the man that is part of the subject of the construction was allowed to sit up there above her looking down at her. I ask, would any of you all have appreciated that?
Can I interrupt you a little bit? We're not, this board doesn't have the ability to discipline Mr. Beam at all. I understand, we all understand what she has gone through. And that's why this case is so complex, is that we have a very, very small responsibility.
Right.
And no, we're getting ready to make a vote here in just a second. Is that we have a very small responsibility. And it is very narrow.
I agree with you.
And there are a lot of things I'm sure that you're aware of that are going to take place somewhere else at a different time. But for us, we have studied this stuff the best that we possibly can, and we're very limited in what we're able to do. And I understand exactly what you're saying.
I agree and I disagree with you, Mr. Thompson. I think you do have a great responsibility, not a small responsibility. I think it's great. I think you do have a narrow area of inquiry. I do agree with that. But I totally disagree with the characterization that you have a very small responsibility. The inquiry of Mr. Klein, I believe it was Mr. Klein, is, and to shorten the response, is to find that these other approvals are in error. That is what she's seeking, to reverse the approval of the others. He's already reversed some of them. he's admitted they were wrong. He hasn't explained to you all how they screwed up or why they screwed up or why they previously approved it. He hasn't explained that. And no one's asked him that. And then the next question after that would be, well, Mr. Beam, because you were wrong before, could you be wrong again? And we ask that you reverse these other 60 approvals, or however many there are, that are set forth in the March 14 letter, which you all have. Thank you, sir.
I believe I think what the appellant is asking for is in the relief sought. She's asking the Warren County Building Department to recognize the errors of their inspectors. There were errors. There's no question about that. It's been proven. We saw more that we found others that we feel are code violations as well. And what she's asking for is for those to be corrected. And I think she has a valid point.
Okay. Okay, I will close the floor for discussion. Right now, we'll have a few minutes to discuss, and then we'll go ahead and we'll make a motion. Okay? Any other questions, Mr. McFadden?
No, this is the letter that he's so stewed up about, this one.
Yes.
It was his first package.
Yes.
Okay, so Mr. Beam has dealt with these individually in his rebuttal sheet,
Yes.
right?
Yes.
And you all looked at his rebuttal sheet and you're satisfied with his rebuttal?
No.
No.
Oh, you're not?
No, it's
All
not.
right, okay. I'm okay, thanks.
Okay, Mr. Hunt, think you have anything else to add? Mr. Crowe?
Yeah, I'm gonna rephrase my question to you. All right? What qualified inspector picked those 60 code violations?
So as the board previously heard, we had a licensed contractor, Class A building contractor, electrical contractor, and a certified and licensed home inspector, Mr. Rushton, who's had licensure since the late 70s, early 80s for various trades in this Commonwealth and multiple other states, come in and do the inspection. Now, the red herring here that Mr. Beam wants to argue, he argued it last time and he brought it up again today. But it's a red herring. And do we all know what I mean when I say the phrase red herring?
The distraction.
Right. The distraction is that he's the only code official here because he's appointed by the code or the county to be the code official. And technically, only the code official can issue violations. So my inspector or my client's inspector doesn't have to issue and can't issue a code violation. He can testify that based upon his training and experience, and if you've ever been a professional witness, the attorney is going to go through a colloquy with you to lay the foundation for your training and your background and your experience in the custom and trade to get your bona fides in before the court, and then he's going to offer you as an expert witness. And you don't have to have the exact same credentia of the other guy. You can have higher, you can have lower, and the trier of fact, the jury or the judge, or in this case, this panel, can weigh the evidence, as we're asking you to do, as the expert that came in here, and I offered him as an expert to you last time, you get to weigh his experience and his interpretation and his review versus Mr. Beam's. Now what's interesting, Mr. Rushton provided a very detailed report, pictures, and then went through in a separate report for you all, set forth how he contends it violates the building code. Or what my client did, excuse me. Set forth how it contends. And if you will recall at the last hearing, I then went through this report with Mr. Rushton. And finally I said to Mr. Thompson, it would take forever for us to go through this. I want you to review this and take it home and review it and look at it. Because it would take too long. And I said, I don't want you to make a decision. I wanted you to review it. And we set forth, my client did, the issues to correspond with the report. And apparently, he's now used some of the same and started a rebuttal, which apparently was submitted somehow before, I don't know, I arrived, or between our meetings. But it's a weighing of the evidence and a weighing of their expertise. Now, you're free to reject, Mr. Klein, that Mr. Rushing doesn't know anything. Maybe that's what you want to conclude. But we already know that Beam's office has made mistakes. There's no suggestion that Mr. Rushing is wrong about anything. But we already know they did screw up. So I suggest to you balancing. But to say that the red herring is, oh, well, he's not a code official. You're right. Mr. Rushing's not a code official. And my client doesn't have the money to hire a code official from an adjoining county or a retired code official. Usually it's about $500 an hour to come in and testify at this hearing for that. But you have a report, you have an inspection report, you have the opportunity to ask Mr. Rushing. He was there last time you were here, he's here today. You ask him anything you want, he can tell you exactly how it violates. Thank you.
Thank you, Mr. Sauer.
Mr. Chairman,
I'd like to make a comment.
Okay, let me, the floor is closed. No, there's no more discussion with the appellant or Mr. Beam at this time. I closed it right before we asked that question. I would like for us to do any discussion that we would need. Mr. McFadden, if you will.
Yeah, I think a good example, like one of the ones on this list, you know, I just looked at as 99, is that one about the stair rise that we discussed. You know, in other words, each of you gentlemen expert in your field went through Mr. Beam's rebuttal and agreed with him, essentially. So, I mean, like, we did look through this list of 60 items. We did. It's not that we ignored them, we looked at them. Right?
Right.
we looked at that 120 something.
Yeah.
147.
Mr. Chairman, I have a statement.
Yes, sir.
I believe that what the job of this board is to determine from the evidence that has been presented whether there are additional code violations. I think that's the question before the board. Not to determine whether the code is right or wrong,
Right.
but determine from the evidence that has been presented to this board whether there were code violations. We've already determined that they were. And that's what the plaintiff is asking for, that those violations be corrected. She's also asking for the things that were not done right in the contract in the building of the house, but that's a different issue for this board. The board had no control over what the contractor did on the job as long as it passed an inspection.
Okay. So, you have any discussion amongst us?
Yeah, I am going to provide my list of items I think that needs to be revisited.
So it's in the minutes.
And we can determine if we want to take a vote on those items. So I think I will be making a motion with regard to these being code violations, and then we can decide if that list needs to be expanded or shrunk.
Okay, that sounds good. Mr. Hatcher, you good for that? Mr. Clem?
And the term you use, revisited, that means that subject to further investigation?
No, further discussion now, because we need a motion to take action.
Yes.
So I'm just compiling that.
Madam Secretary, please get ready to present the items that we feel that.
Okay. I make a motion that we relook at and discuss for potential violation of this list, which is the list provided by Mr. Beam. Item 6, You might want to take these down. Item 10, item 20,
Don't go so fast.
sorry,
6, 10, 20,
item 23,
23.
item 37, item 38, item 92, item 93,
92.
and item 101.
And then look at my list. Did you get all of them?
Read those out again, please.
Sure, to repeat the same, items 6, 10, 20, 23, 37, 38, 92, 93, and 101.
How about 11 and 12? Post. That post is not supported.
Yeah. About it.
The items that were cited as violation, I didn't, oh, yes.
Because even,
Amend that list.
even the
Yes.
inspector said that was questionable.
Amended with number
11,
11 and 12.
thank
And
you.
12,
Yes.
So can we repeat
About-
the motion?
22.
22. Yeah, 22. And 23.
Yeah, I got 23.
Got 23.
Okay, 22.
Okay, let me remake the motion. Any others?
38. 70.
Are we just
73.
going to discuss this? or you
Yes.
take
Oh,
on
return to the weather.
Well, we have to make the motion first before we can discuss all of these.
Okay.
So I will restate the, to relook at item 6, item 10, item 11, item 12, item 20, item 22, item 23, item 37, item 38, 92, 93, and 101.
As in the form of the motion,
Yes.
I second.
We have a motion on the floor to discuss the following numbered items: 6, 10, 11, 12, 20, 22, 23, 37, 38, 92, 93, and 101. All in favor, say aye.
Aye.
Any opposed? Motion passed.
I believe these items, and I say I believe, are code violations.
Mr. Crown, did you have any discussion? Mr. Fat?
No, sir.
Mr. Hotep? Well, I tend to agree. And I think if someone would want to make the motion with these items, we could vote on it at this time.
I'll make a motion if you can help me.
Mr. Chairman?
Now, yes, sir?
Would it not be appropriate to give Mr. Beam some chance to say something?
No, the meeting's closed. Yeah. Now, when we make a motion, members, I want to make sure we have to make a motion to accept or deny the appeal.
Well, can we accept it as part? Not as part?
Yes, yes, we can.
I'd like to make a motion that we accept the appeal as far as building code violations are concerned with the numbers that's already on record. Is that good enough?
Yes.
That's the motion.
Okay.
Repeat that.
The motion
I
is
can't.
made to accept the appeal with the numbers listed on record as 6, 10, 11, 12, 20, 22, 23, 37, 38, 92, 93, and 101. Do I have a second for that motion?
Second.
And I don't guess I can take anything else at this point.
You second?
Yes, yes,
Okay, we have a second on the motion. All in favor, say aye.
Aye.
Opposed?
Yes.
Motion passed.
I'd like to make a motion the meeting adjourned.
I have a motion on the floor to adjourn the meeting. Do I have a second?
Second.
All in favor,
Aye.
say aye. All opposed? Meeting's adjourned.